Welcome to the deep dive. Our mission here is, well, pretty simple. Take complex stuff and break it down so you feel totally informed without needing to wade through loads of text yourself.
Exactly. And today, we're not just looking at articles. We're going straight to the source, the rule book for patent examiners.
That's the Manual of Patent Examining Procedure, right? The MPEP.
The MPEP itself, think of this as your guided tour, focusing on one really important part.
And for this dive, we're zooming in on Chapter 2100. That chapter covers patentability, which is pretty fundamental.
Super fundamental.
Specifically, Section 2123. The title's a bit of a mouthful. Rejection over prior art's broad disclosure instead of preferred embodiments.
Yeah, sounds technical, but the core idea is actually crucial for understanding patents.
So what's the gist?
It basically means when an examiner looks at old patents, that's prior art, they don't just look at what the original inventor highlighted as their main invention. They can use everything that old patent discloses, the whole thing. Even the options the inventor didn't seem to like as much.
Right. So Section 2123 tells us prior art is the whole disclosure, not just the best bits.
Precisely. And understanding this is like a key insight into how patent examination works and what counts as existing knowledge.
Okay, let's get into it.
Absolutely. So the basic principle, like you said, is that a patent is prior art for everything it contains. And this isn't just policy. It's backed up by court cases.
Which ones are we talking about?
Well, key ones mentioned here are Inri Heck and also Inri Lemelson. These are pretty foundational in this area.
Okay, Heck and Lemelson. What did they establish about this broad disclosure idea?
They really solidified that prior art isn't limited to the main point. It includes anything reasonably suggested to someone skilled in that technical field.
So, person skilled in the art is the standard.
Yes, exactly. If that person reads the whole patent and sees something suggested, even if it's called a non-preferred alternative,
It still counts.
it still counts. It's considered disclosed to the public. The system cares about what knowledge was shared, not just what the inventor thought was optimal.
That really raises the bar for proving something is new, doesn't it?
It definitely does. It's about what's out there, period.
Okay, that makes sense. Let's make it more concrete. Are there good examples of this in action?
Oh, definitely. The MPEP points to several. Take Merck v. Biocraft Labs.
Okay, Merck. What happened there?
So there was a prior patent that mentioned a component but said it was optional.
Right.
The court decided that disclosing it as optional actually teaches both using it and not using it.
Wow. So just flagging something as optional covers both bases for prior art.
Exactly. It
What?
shows the idea was already considered and put out there. Another one is Upshur-Smith Labs v. Pam Lab.
What was the situation in Upshur-Smith?
Similar idea. A reference described multiple possible formulas or compositions. Maybe the inventor preferred one.
But they listed others.
Yes. And the court said, well, all those listed compositions count as prior art. Doesn't matter which one the original inventor liked best. Just describing them was enough.
It's like saying, look, these options were on the menu already.
That's a great way to put it. You can't just pick one off the old menu and claim it's brand new just because it wasn't the special.
It gets even trickier, though, right? What if the prior art seems to suggest not doing something?
Ah, yes. That brings us to Celeritis v. Rockwell. This one's really interesting.
How so?
In Celeritis, the prior art actually described a method, but noted it wasn't ideal, maybe even hinted it was suboptimal for a certain purpose.
Okay, so it kind of steered away from it.
You'd think so. But the court still found it was anticipatory prior art. And here's the crucial line they use. Suboptimal does not mean absent.
Suboptimal does not mean absent. That's powerful.
It really is. Just because a prior patent says this approach isn't the best, doesn't erase the fact that it disclosed the approach.
So you can't patent that not the best approach later just because the first inventor pointed out its flaws.
Not usually, no. It's still disclosed knowledge.
Right.
Now, there's a related concept called teaching away, which is a bit different.
Okay, we'll get to that. But just being called less effective isn't enough.
Correct. And other cases back this up, like Inri Susi and Inri Gurley. They basically confirmed that known or obvious variations don't suddenly become patentable just because prior art called them less effective.
So the examiner's really looking at the entire picture painted by the prior art.
The whole landscape, yes. Not just the sunny spots the original inventor pointed to.
What about when prior art lists say a whole bunch of different options? Does that make it easier to patent something specific within that list?
You might think so, but not automatically. There's a case in Fulton that deals with this.
And what did Fulton say?
It clarified that just because a prior patent lists multiple alternatives, it doesn't necessarily teach away from any specific one you might later claim.
So having choices in the prior art doesn't mean picking one is automatically inventive.
Exactly. The options were already known. Now, the exception is that teaching away concept we mentioned.
Okay, so what is teaching away, officially?
Teaching away happens when the prior art doesn't just say something is less effective,
Mm-hmm.
but it actively discourages or criticizes the specific thing you're trying to patent.
Like it explicitly says, don't do this, it won't work, or this approach is problematic.
Precisely. It has to actively steer someone skilled in the art away from that solution.
Mm.
If it just lists options or even says one is suboptimal, that's usually not enough to be teaching away. It's still just disclosure.
Got it. This all feels incredibly important for anyone actually navigating the patent system.
Absolutely critical.
So for you, our listener, why is really internalizing the section 2123 so vital?
Because it directly impacts how you argue against a rejection, or even how you assess patentability in the first place. If an examiner cites a reference against your application.
You can't just say, but they preferred something else in that patent.
Exactly. That argument usually won't fly. You need to show that the reference actively teaches away from your specific invention, that it discredits or disparages it.
Otherwise, the examiner can rightly use that whole disclosure.
Yes. Based on the laws, like 35 U.S.C. 102 for novelty and 103 for non-obviousness, that broad disclosure is fair game for those kinds of rejections.
Knowing this upfront saves a lot of wasted effort, I imagine.
Huge amounts. It helps you understand the examiner's perspective and frame your arguments effectively.
So the big takeaway for you listening is, read prior art patents thoroughly. Don't just skim for the preferred embodiment.
Look at everything. Every alternative, every optional feature, even things mentioned as less effective.
Because unless that patent explicitly tells you not to do something, that disclosure can potentially block your own patent application. Section 2123 makes that very clear.
It really does. It underlines how much the entire scope of prior disclosure matters in patent law.
It shows the depth of what's considered known.
Precisely. Innovation builds on what came before, and the patent system takes a very, very broad view of what came before.
This has been really clarifying. It underscores the careful reading needed by both examiners and applicants.
And hopefully, this deep dive into Section 2123 gives you, our listener, a useful handle on this. Makes you think, doesn't it, about how much is packed into existing patents.
And how that might impact your own work or your understanding of the patent landscape.
Definitely.
And just a reminder, this is one installment in our ongoing series exploring the MPEP. We'll be back with more sections soon.
Right. And a couple of quick but important notes. First, this whole series aims to help you understand the MPEP, whether you're learning, practicing, or applying for patents. We focus on specific sections to make it digestible.
And the disclaimer.
Yes, always. This summary used AI tools in its preparation, and it's purely for educational info. It might have errors. It's not legal advice. You always need to consult the official MPEP documents or talk to a qualified instructor or a registered patent practitioner for real guidance.
Absolutely crucial. And we also want to give a special thanks to Mike Shepard.
Yes, Mike's the creative director behind this whole educational series. His vision and organization are what make these deep dives possible.
Indeed. Okay, that wraps up this exploration of MPP Section 2123. Thanks for joining us on the deep dive.